Hey, good morning again. It's John Maiden. It's about 7:35 on September 21st. I fell asleep for a couple hours. I'm under a lot of stress once again, which is what these people seem to enjoy doing to a disabled person like me, is to cause me so much stress that it induces panic attacks and clusters of panic attacks for that matter. And anyway, let's read this. Get this on the record. This is what Cheryl Maxwell, submitted in response to my appeal, which tells you how fucked up and how far off base this lady is, and that she's got to go. So we're gonna read this into the record. Let's read the whole thing. I don't care how fucking long it takes, because this genius is gone. It says Supreme Court Appellate Division, State of New York, 3rd Department, in a matter of proceeding under Article 6 of the Family Court Act, which is for custody and visitation, me versus Kristen. This is the attorney for the children's brief, Cheryl Maxwell, super genius, attorney for the subject children, otherwise known as guardian ad lackey, guardian ad nauseum. This person is not in favor of children in any way. What this person is in favor of is her own ego and her own bias and whatever relationship she has arranged with Lawless Bruno and these other creeps. So, all right. So we've got the table of contents, the attorney for the children's brief, preliminary statement, questions presented, statement of facts. Wow. Decisions of the court in declining to recuse himself was not an improvident exercise of discretion. Point 2, the decision of the court in dismissing the appellant's custody and visitation petition was supported by a sound and substantial basis in the record. Really? Really? Then we have a conclusion that she entered. Then she do a certification per statewide practice rules, statement pursuant, notice of appeal dated April 30th, dismissal. Thank you very much. We're going to make sure we use this at the next stage because, I plan on tearing it apart. Wow, so I was wrong. I really can't read this. It's way too fucking long to read. Anyway, let's go through it real fast. We'll see how we go. Preliminary statement. On July 27th, 2021, John Maiden, hereafter the appellant, filed a petition in the Clinton County Family Court seeking to modify a custody and/or visitation petition. The case was heard by the Honorable Keith M. Bruno, hereafter Judge Bruno. Kristen Carnahan, the children's mother, hereafter the respondent, opposed the relief being requested, asserting there had been no change in circumstances since the controlling order was entered. Over the course of these proceedings, the appellant made 2 oral motions and 1 written motion to have Judge Bruno recused from presiding over the case. At the core of the request was the fact that Judge Bruno had represented the respondent in 2012, over 8 years ago, to the instant proceedings. Judge Bruno did not find a basis to step down. He advised the litigants that he had represented respondent over 8 years previous. He had no recollection of her case. He had been on the bench for over 4 years and did not find a basis on which to recuse himself. To say this decision infuriated the appellant would not be an understatement. The appellant argues on this appeal that Judge Bruno's failure to recuse himself was an abuse of discretion. 2 appearances were held prior to the trial. Although efforts were made with the assistance of the court, a settlement was not reached. The appellant's behavior throughout the course of the litigation was fraught with anger and disrespect of the court, counsel, the parties, court security, and the judge himself. A trial was held on April 8th, 2021. The parties gave opening statements, testimony was taken. Although encouraged by the court to continue with the presentment of his case, appellant declined to do so. At the close of the evidence, respondent made a motion to dismiss and a motion for attorney's fees based on frivolity. Judge Bruno granted the motion to dismiss the appellant's motion and denied the motion for attorney's fees. Appellant argues on appeal that the dismissal of his petition was not based on a sound and substantial basis in the record. Questions presented. Number 1, did the Clinton County Family Court judge exercise sound discretion in declining to recuse himself from the case? And question number 2, did the Clinton County Family Court judge's decision to dismiss the appellant's petition with prejudice have a sound and substantial basis in the record? Statement of facts. This case concerns 3 children, Elizabeth, Victoria, and Aurelia. They are 14, 13, and 12 years old, respectively. On June 8, 2017, represented by counsel, appellant consented to an order granting the girl's mother, respondent, sole legal and physical custody of the daughters and supervised visitation with the children for himself, as arranged with and supervised by the Child Care Coordinating Council of the North Country. Family connections. By appellant's own admission, at the time of the trial, he had not seen his children in 8 years. On July 27, 2020, the appellant filed a pro se Article 6 petition in Clinton County Family Court. He sought to modify the 2017 custody and/or visitation schedule. At the initial appearance, appellant was repeatedly advised of his right to an attorney, A205, 211, 212, 215, 216. Due to the nature of the pro se petition, it was challenging to discern what provision of the controlling order the appellant was seeking to change. Appellant sought either legal custody of the 3 children he has not seen in years or a modification to the visitation schedule. The family court judge, Keith M. Bruno, hereafter Judge Bruno, made repeated attempts to determine what relief the appellant was seeking. Eventually, Judge Bruno determined it's hard to decipher from his petition what relief he is seeking, but I guess reading between the lines, you could take it as possibly a custody modification petition, and it is a pro se petition. During the initial appearance, the appellant became increasingly confrontational and disrespectful to the judge, the attorneys, and the court personnel. A number of times the respondent yelled at the court and was admonished to keep his voice down. He was told there was no reason to raise his voice. The appellant was taking over the court, that the court was trying to be courteous. In spite of the admonitions, the respondent continued to test the court's patience, causing the court to respond by stating, "Mr. Maiden, I don't appreciate your comments with respect to this matter. I'm trying to be understanding. I don't appreciate your comments about an officer of the court either. Sir, when an officer of the court, specifically a security officer, is giving you a direction, I would ask you that you follow the direction of the officer. Do you understand that? There is no reason to raise your voice. I'm listening to everything you have to say. I'm trying to be courteous. You're talking over me." No apology from the appellant was forthcoming, nor was there a modification of his behavior. The appellant made an oral application asking the judge to step down, stating, "But why won't you recuse yourself in this matter? You were Kristen's attorney in 2012. The appellant request stemmed from Judge Bruno's representation of the respondent over 8 years ago, prior to the instant proceeding. Judge Bruno answered the appellant's question by stating he would not recuse himself, finding no basis to do so. Judge Bruno explained the rationale, for his decision, indicating he was not currently the respondent's attorney. He had been her attorney over 8 years previous to the proceedings at hand. He'd been a jurist for over 3 years. He had no recollection of the content of his prior representation. In his opinion, he did not have a conflict of interest. A216. The appellant now argues this decision was an abuse of discretion. When dates for the conference and trial were set, respondent inquired regarding visitation. He stated he had not seen his children for 8 years. A214, 217, 218, 219. There was no agreement to modify the terms of the 2017 order on a temporary basis. A219, 220. Initial appearance ended. On January 26, 2021, a virtual conference was held. During this appearance, respondent indicated that he was not seeking custody, but instead visits. At this appearance, the respondent stated that he had not seen his children in 9 years. He had seen his children 3 times in 9 years. Respondent attempted to negotiate. Judge Bruno assisted the appellant in his endeavor for contact by asking questions to determine if behavioral health services, therapeutic foster care visitation, a youth advocate program on the corner next to Crookshank's office, family connections, or a third party were available for supervised contact. Attempts at settlement were unsuccessful. The parties in the court were advised by the attorney for the children that she could not consent to a temporary modification of the order, stating, "Your Honor, just that you understand my position. Obviously know that I don't determine what's in the best interest of the children. I simply advocate their position. They're old enough to tell me what they would like to have happen, and my clients have not seen their father in a long while. They do not want to see their father, and so I am not. I do not have their authority to assist their father in finding a manner in which he can see them." Unfortunately, during this conference as well, the respondent chose to be as disrespectful of the parties and the court as he had been during the initial appearance. Respondent made comments such as, "I did not attempt to contact Ms. Maxwell at all. I'm afraid it will be construed incorrectly and she'll come up with some bullshit thing that I said wrong. So I'd rather, go play in traffic than talk to Ms. Maxwell. You have no interest in what's best for my daughters. You just have interest in punishing me. No, make no mistake, I'm attacking all of you. Let's be clear here. I'm attacking all of you. You're all guilty of fucking perjury." This tirade went on for some time until the court intervened, saying, "All right, Mr. Maiden, Mr. Maiden, Mr. Maiden, Mr. Maiden. You're interrupting, Mr. Maiden. You're interrupting the court. I'm trying to be civil, and you're being uncivil toward the court, especially with your comments with respect to it. I'm not going to put up with it any longer. I tried to listen to you as to what your settlement is with respect to it. No resolution could be arrived at today. It takes 4 people to agree." Judge Bruno advised the respondent that there would be a trial to determine the issues and again reminded the respondent of his right to an attorney. A virtual trial was scheduled for March 5th, 2021. When that appearance began, Bruno attempted to determine if the parties would consent to proceeding virtually. The appellant chose not to answer the judge, instead making a second oral motion for the judge to recuse himself, stating, I have many objections, sir. I think you need to recuse yourself, first of all. You need to get out of the way. You shouldn't be involved in this at all. You were Kristen's attorney back in 2012. Now you're the judge in this matter. Are you going to pretend that you should be there? You gotta recuse yourself and allow justice to take shape. This is not a legal forum as long as you're sitting on the bench. The appellant went on, no, I want this to go ahead in person. I want a real trial so that you can't whitewash this on Friday afternoon and dismiss this for some horseshit reason like I didn't meet some causative action or burden or something that Alan's going to suggest here in a minute. So why don't you just put Alan on the stand? I'll walk him through this horseshit document that he sent to the court that has 60 points in it, but he didn't feel brave enough to submit it to the court and send it to me as a love letter through the mail. What is this shit, Alan? What is this? The appellant continued his rant. You need to get out of the way, Judge. Otherwise, this makes no sense. This isn't a little illegitimate court with you sitting on the bench. This is a joke. This is a joke. I'm going to take you to federal court to do whatever you got to do today. I have more than enough documentation to prove everything once I can get out of this kangaroo court. Judge Bruno attempted a response by stating, I'm not appreciative of you calling this a kangaroo court. I'm not appreciative. Interrupting the judge mid-sentence, the appellant stated, as long as you're sitting there, it is a kangaroo court. Excuse me. Judge Bruno, attempting to establish decorum, stated, Mr. Maiden, I'm speaking. I'm not appreciative of your comments whatsoever. One, I'm not going to recuse myself with respect to this matter. Let me speak. That apparently has been well over 7, 8, or 9 years ago, and certainly not since the court has been on the bench for the last 4 or 5 years. The court has no recollection. You're interrupting me. The court has no recollection of previous representation of Ms. Carnahan. Appellant responded, I don't care what you're trying to do. This is a kangaroo court. This court is illegitimate. Finally, having reached a complete impasse, Judge Bruno stated, all right, I've had clearly enough. Clearly, Mr. Maiden, if he was in the courtroom, would be reprimanded by the court with respect to it. Appellant, still behaving extremely inappropriately, said, clearly, you wouldn't be on the bench. You wouldn't be sitting there. Then in the pinnacle of disrespect, this whole thing for years is the pinnacle of disrespect, but Maxwell says that to her, this is the pinnacle of disrespect, is that I am correct in calling out all of this illegal activity and all these illegal actions against me. That would be the pinnacle of disrespect to her, is to challenge some asshole like Cheryl Maxwell who believes that she's infallible. Just like Bruno does, just like Lawless does. These are arrogant fucking pricks that have no real regard for the law. Just their own egos. So on April 28th, 2021, an in-person trial was held. At the commencement of the trial, Bruno noted that the appellant had made 2 oral motions for his recusal, both of which had been denied. Judge Bruno noted the appellant had also recently filed a motion seeking recusal. The parties filed answering papers. Judge Bruno stated he had reviewed all the papers and denied the appellant's motion, indicating he found no basis for which to recuse himself. The trial commenced with all parties making opening statements. At the conclusion of the opening statements, the appellant called his first witness, the respondent. The respondent initially refused to testify. After an oral argument on the issue, the court agreed with the position of the attorney for the children that the respondent should be compelled to testify. Otherwise, Bruno wasn't even going to let Kristen testify. And Maxwell really doesn't want her up there either, unless it's in a very controlled circumstance where I'm allowed to ask her questions that have to do with, like, the previous 60 days or something. I don't fucking know. Not that she committed perjury 100 times in the last, 10 years, but the court is all about that because they set it up long ago. So the appellant asked the respondent 5 questions without objection. Those questions provided the court with evidence that the parents have 3 children, that the children were born in Pennsylvania, that the maternal grandmother brought the children to visits at Family Connections, that there was a disagreement regarding the visits at Family Connections, and that the visits at Family Connections stopped. No evidence was offered as to the reason the visits were discontinued. Following his questioning of the respondent, the appellant stated, this is going nowhere. I give up. That is not an accurate representation of what happened. She's fucking lying here. Well, I'm not stopping you from asking questions. Sir, you called her to the witness stand and I'm allowing you to question. Judge Bruno was interrupted by the appellant. Bruno tried again and again, stating, we're in a trial. I'm not doing anything. I'm trying to talk to you without being interrupted. That's all I'm trying to do is talk to you. And if you'd stop talking and listen, you have a trial. We're in the trial. You called a witness. What I said to Kristen was, will you agree that you and I have 3 daughters together that were born in Pennsylvania? Now, Kristen wouldn't answer. This is not accurate, what Maxwell is saying in here. You need to check the transcript on this one. Kristen did not answer this way. She's lying. Maxwell is lying. There's a lot of lies in here. I'm sorry I stopped reading. I said I wasn't going to do that. But there's just some things I can't get past without calling out. All right. Appellant continued to argue with the court, stating the proceeding was illegitimate. In spite of the appellant's disrespectful behavior, the court continued to encourage the appellant to continue with his case, saying, "You're stating you want to go to a higher court. You have that right, but we're in the trial you wanted, and you called a witness. I'm asking you for the second, third, or maybe fourth time, do you have any questions for Mrs. Carnahan?" The appellant continued to attempt to engage the court in argument. The court simply explained that questions must be material and relevant and based on rules of evidence. That's not true. Respondent, angry with the court's information, again told the judge he needed to recuse himself. Given no other options, Bruno accepted that the appellant had finished his direct examination of the witness. The respondent's counsel asked one question of the witness. It was, "Has anything in this situation between yourself and Mr. Maiden and the children changed since June of 2017? The witness answered in the negative. The judge then attempted to discern no less than 3 times whether the appellant had any additional evidence he wished to offer. Eventually, the appellant answered, "No, sir. Let me get out of here. I mean, this is too much. Really, it's absurd." And it is, was, and has proven to be fucking absurd. So stand around for the next round of absurd. At the close of the appellant's case, the respondent's counsel renewed the motion to dismiss the petition for failure to establish a prima facie case and attorney's fees. All parties were heard on the motion. At the conclusion of the argument, the court took a brief recess to consider. When Judge Bruno returned to the courtroom, the appellant's petition was dismissed with prejudice. With prejudice. Now, this guy, since Maxwell wrote this and everything, this guy was found to, according to whatever less than prima facie is, it's that the 3rd Judicial District was afraid to turn the page and learn more about all this shit. So they just said, whoa, Judge, you should never have looked at this fucking shit at all. So we're going to agree from the door that this should go away. But really, it's the attorney for the children that agrees with you on all this shit. And apparently Crookshank does too. So the attorney for the children, she's agreeing to everything you say. And, after all, you are lawyers. You're officers of the court. We believe that you are not doing anything wrong or acting improperly. So we're going to write this and craft it in such a way that we're going to allow you to cover your asses. So that's what went on. So at the close of the appellant's case, the respondent counsel renewed the motion to dismiss the petition for failure to establish a prima facie case and attorney's fees. Again, my prima facie case, as it has been, is based on the fact that Kristen has perjured herself again and again in front of Keith Bruno, Timothy Lawless, all these people. The conspiracy is in place to allow that occur, and the actions have been taken over and over the years to foster this behavior. That's why we are today, why we are where we are today. I don't have any rights. They've taken that long ago. Now we're going to get Lawless back in there, and all I can do is hope to collect information again and try to get this down to Albany one more time, where I've pissed off everybody just about down there too, because none of them want to get involved in this mess. There is nobody on the planet that wants to step into this horseshit. Argument 1, point 1. The decision of the court in declining to recuse himself was not an improvident exercise of discretion. Now, this is a good one. Appellant sought to have Judge Keith M. Bruno recuse himself from the proceedings on 3 occasions. Each time, Judge Bruno considered the arguments and ultimately held that there was no basis on which to recuse himself. The appellant incorrectly argues that this was error. Really? Absent legal disqualification, a trial judge is the sole arbiter of recusal, and his or her decision, which lies within the personal conscience of the court, will not be disturbed absence of an abuse of discretion. This is absolutely an abuse of discretion. People versus Patrick, people versus Durham, people versus all of these half-assed arguments she makes in support of Judge Bruno. Not in support of my motions, not in support of parental rights, not in support of anything except what she's already predetermined as being her half-assed, biased, discriminatory, highly prejudicial opinion, where she has crafted these questions with my daughters after being alienated from me for so long that what would you expect their answers to be? They're also afraid that the 4 of them are going to be broken up and that Elizabeth, Victoria, and Aurelia will be separated from their little sister, Brinley. And this is all, the court should be held accountable for all of this because it is their actions, as Maxwell tells you, that they just plow ahead. They don't give a fuck what I have to say. They don't even bother to look at it or consider the ramifications that I'm talking about. So unless disqualification is required, which it is, disqualification is required. A judge's decision on a recusal motion is one of discretion. Wow. Recusal as a matter of due process is required only where there exists a direct, personal, substantial, or pecuniary interest in reaching a particular conclusion of where there is a clash in judicial roles is seen to exist. Exactly. You put your finger right on it there, Maxwell Smart. That's exactly what Albany said, was that this motherfucker, it's such a gross violation of his discretion that he can't sit here, and neither can you, for that matter, after this writing. The Court of Appeals has held that for any alleged bias and prejudice to be disqualifying, it must stem from an extrajudicial source, such as resulting in an opinion on the merits on some basis other than the judge learned from his participation in the case. I don't know what else she's saying here. It's not enough for a party to allege bias. Instead, he or she must point to an actual ruling that demonstrates the act. Oh, I can do that, and I showed you. I held up in one of the previous proceedings where I showed you that not just once, I think twice in Clinton County, once in Pennsylvania, but definitely twice in New York, it was Keith Bruno, while he was representing Kristen Dupree, my ex, that they initiated with the court. They filed a petition in front of Judge Lawless to initiate an investigation into allegations of child abuse and domestic violence against me. This was the agreement made with Lawless so that Lawless could take actions against me and create legal jeopardy for me if I ever came to New York. Now that's what was put into place, and now that legal jeopardy is coming around full circle again, because I fought to get Lawless removed from this, after this shit show thing in 2018 to 2019, where he kept dragging this thing into integrated domestic violence court and trying to use those higher punishment, and sentencing guidelines to try to hang me up and put me away for a couple of years. So that's what this guy is really all about. Don't be mistaken. But in response to my motions, Bruno stated that he had no memory of the respondent's case. That doesn't matter. Oh, my God. Even my half-assed attorney in the appeal, Todd Monahan, who I found out is like some autistic weirdo or something. I don't know who the hell he is. Even my weirdo attorney, Todd Monahan, who's afraid to talk to me on the phone, when somebody states that they had no memory of the respondent's case, maybe he's heard of, the computer and court records and verification of his own bias, or to see what the fuck he did if he doesn't remember. And what he didn't take any of those acts. He never attempted to remedy this any other way, that his prior representation did not prejudice his participation in the matter. Who cares? If you were there and there's an appearance of impropriety, you're done. That's what Albany said. But Albany didn't address anything that occurred before this or any of the implications of this ruling after this. So they just reversed it. And of course, Clinton County picked it up and threw it to Timmy Boy, Tiny Tim. So, appellant's motion for exercise of discretion to deny the appellant's motion for recusal where the judge harbored no prejudice against the appellant. The judge had not reached a conclusion as to the outcome of the case prior to the conclusion of the trial, and the record reflected no instance in which the court exhibited prejudice. Really, Maxwell? We'll have fun with this one. One has only to look at the even-handed manner in which Judge Bruno dealt with the appellant. You're laying it on thick now there, Maxi Poo. In the face of his rants and disrespectful behaviors toward the court. My rants and disrespectful behavior toward the court are founded in these people abusing my children. This is state-sanctioned child abuse. This is child abuse that is enabled because of the biased, highly prejudicial, discriminatory decisions and actions made by Timothy Lawless, Keith Bruno, Cheryl Maxwell, Alan Cruikshank, all of these people who are in court now. And what you're seeing is that these other people who come into court, unless they're on Cheryl Maxwell's side, which Lynn Ormsby is made to appear that she is Saint Lynn Ormsby of Peru. And this lady's Ricky Carnahan's mother, for God's sake. If that doesn't disqualify her as a parent, I don't know what does. But, they seem to favor her, although she doesn't really have any standing. And what this is going to come down to is an argument in court where they're going to try to declare me unfit. And, you know, if that's what they're going to do, then let's I don't know, I'm not going to defend myself to this in this video, but you got to understand how far off base this all is. Now, I've only read about, what are there? I was on page 14 of 24, but you got to understand, you know, this is corrupt, highly unusual. It's documented again. What you saw that was decided in Albany was shit that has accumulated and that I have forced onto the record in 2020 and 2021. And that's what this was decided on. So that's a very narrow focus as to the level of corruption, misrepresentation, bias, discrimination, you name it, that's going on since then. Now, what really lit the fuse was Ricky and Kristen and their, you know, I guess legal problems in Peru, May 10th and May 12th. Again, they're doing a good job of whitewashing that and covering it up, as they always do whenever Kristen's involved. She never pays a price for her addiction, for her abuse, for her destruction of my daughter's lives. So, we'll see. Court at 2:15 today. If you don't hear from me, it means Lawless threw me in jail. See ya.